So, Miss Hennigan and Miss Berta, I do have Mr. Tetters, so we can take care of him. So, awesome. All right. Mr. Tetters, you want to come up and stand at the.
There's a message on Zoom.
Okay. Yeah, it always comes up.
Okay.
All right, Mr. Tetters, do you have gum in your mouth?
Yes.
Okay, so why don't you use a tissue and spit that out?
Sure.
You don't chew gum in a courtroom. Okay, so this is in the matter of the people of the state of Michigan versus Kenneth Charles Tetters, file number 23-21265FH. I have Christy Berta, P43149, appearing on behalf of the Attorney General's office, and I have Tamaris Hennigan appearing on behalf of Mr. Tetters. What's your P number, Miss Hennigan? I should know it, but I don't.
P81968, Your Honor.
All right, thank you. I did receive an email, well, a memo from Darren Coase to his pretrial services coordinator, and it is dated January 15th. It states, Mr. Tetters recently paid $7,670.96 to bring his balance to zero, and he has done a tremendous job catching up with his support obligations. So I don't know if my notes are up to date, but the notes I had stated we would delay sentencing 11 months. If he reduced it below 8,600, it would be an attempted failure to pay. And if it was zero, it would be a disorderly. Is that still the plea offer that was entered that day?
It is, Your Honor. And we bumped it in August and November to allow him time to, first he bumped it to an attempt and he wanted to try to earn the disorderly, and we agreed to that. And I can confirm, as did your probation officer, that the arrearage has been eliminated. The people would be moving to add account 2, disorderly person, under MCL 750.167, and would be moving to dismiss counts 1 and the habitual offender notice.
Okay, so Miss Hennigan, is there any objection to that?
No objection, Your Honor.
All right, so Miss Berta, procedurally, do I need to obviously withdraw, do I need to on the record withdraw his plea and then have him plea, or how do other counties? Most people don't pay it off, so huge kudos to you, Mr. Tetters. So this rarely happens in front of me, and I don't remember what I did the last time. So
I believe
does he need to re-enter a plea?
I don't believe so, Your Honor, because this is still the disorderly person statute still says had the ability to pay and didn't. So I believe that the factual basis tendered at the time of the initial plea is sufficient for the added count 2.
Okay, so because we have not sentenced him today and because he's been in full compliance, Miss Berta, I guess I would ask Miss Hennigan as well. I typically wouldn't do a probation term on this because he's paid in full. So there's,
We'd just be asking
state costs. Okay, okay. So Miss Hennigan, do you have any objection when I sentence him today for the misdemeanor that it just be the state costs and crime victim rights fee?
No, Your Honor, we'd have no objection. That was the goal that my client was working towards.
So, Mr. Tetters, there was a pre-sentence report that we provided to Miss Hennigan. Did you get to review that with her? Probably 11 months ago, maybe?
I don't even remember. Yeah.
Okay, and it was the felony pre-sentence report that just went through your background, the amount owed, and stated fines, costs, in terms of probation, which pretty much now is not applicable because it's been reduced to a disorderly. So my intention today, because you've been in compliance, which, as I said, is amazing because most people don't do that for us. It would just be on a misdemeanor. I think it's $50, and let me see, a crime victim rights fee is $75 and a state cost of $50, which you could pay in like 45 days. So Do you need time to review the pre-sentence report for the felony that existed, or
As long as it's no longer, I don't need,
it doesn't apply anymore?
yeah, I don't.
Okay, all right. So, Ms. Hennigan, is there anything you'd like to say? Well, I'll start with Ms. Berta. Anything you'd like to say on behalf of the Attorney General?
No, Your Honor. Obviously, we're very pleased with this outcome. January child support has been paid. It will continue to accrue given the age of the children. And so we hope that he will continue to make his payment obligations.
Okay, Ms. Hennigan, anything you'd like to say on behalf of your client?
Your Honor, just my clients worked very hard at this. I know that at our last conversation, the children were staying, at least one of the children was staying with him, and he's hoping to get the other child to stay with him as well. So he did accomplish this goal while having full-time care of one of these children. And so even more of a challenge than usual. And as you stated, this does not usually happen. So Mr. Tutters has made a great effort to get this situation cleared up and to become a full-time father to his children. And I know that he has expressed to me that he's going to take the proper steps needed with FOC to have the child support reviewed, since he is caring for the children in a different manner at this time. Thank you, Your Honor.
So, Mr. Tedder, anything you want to say on your own behalf? And then I have some questions about, you have a child staying with you that there was a child support order on. Please tell me you petitioned through the court.
That was going to be how I wanted to handle this first, and then.
Okay.
All the money was.
Right, because if one of these kids is staying with you, we only go back to the date of filing. So say, for example, that kid's been living with you for a year. When you file a petition through front of the court for a hearing on that, it only goes from the date of the petition. So.
I would also care about the time.
Okay. Well, I'm just talking about arrearages and child support issues. So, all right, Mr. Tutters, anything you want to say on your own behalf?
I know you guys have everything set up the way you're supposed to. I appreciate you guys just in general. I was hoping if it was just a small little quote that it could just be dropped, and I could start tackling everything else, especially with my children. But I mean, I just want to say thank you to everybody.
Well, I think we're more appreciative of the effort and time you put into paying off this arrearage, because it wasn't a small amount. Like I said, people very often do not successfully complete this. What I would advise you is, if you have a child living with you today, you go file a petition for a front of the court referee hearing for a change of custody or recalculation of child support, so that this, doesn't happen again. Because if I've had people pay it off and then get another arrearage of 20,000 in 5 years, and then they'll charge you again, and no, we don't want this. No.
This is a valuable learning lesson.
Oh, yeah. Okay. Thank you. So I'm glad it was a learning experience, and I hope it works for other people too. So make sure you file the paperwork you need to file, and make sure you know your monthly amount, make sure you're paying it. And all right. So in determining the appropriate sentence in this case, court, that's my phone. I'm sorry. I got search warrants coming up my butt right now. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law and protection of society. It's a sentence of the court that you will pay a $75 crime victim rights fee, $50 in state costs. I don't see any purpose for probation or any other things. I know the financial burden that you went through to pay this off, And you have like 45 days to pay that. And it would be paid at the clerk's office.
I'll pay that.
Yep. So my bailiff's gonna hand down to your notice of right to appellate review. I'm gonna need you to initial and date one copy just for our record, so we know that we received it. And then the others are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right? Right, and the record should reflect Mr. Tetters has signed the notice of right to appellate review, and I'm gonna place that in the file. Good to see you, Mr. Tetters. Have a wonderful 2025. Ms. Hennigan, always a pleasure. Ms. Burdock, same to you. So have a good day. And now you'll do a stip in order to amend that. I
Yes,
think it's done by step, right?
My office will send it over, Your Honor.
Miss
All right,
Berta,
excellent.
Miss Berta, you can sign it with my permission.
All right, thank you.
Thank you. You're good. Thank you. Happy New Year. All right, give me 1 second. I'm gonna bring the jail in, Mr. Malaro, and then I've got a search warrant I gotta look at. They know I'm a morning person, so they start sending to me at like 6 in the morning.
Oh, my.
Yeah. All right, I have somebody from the jail. If there's somebody in there, could you start your video?
I started.
All right, who are you? Mr. Boone?
Yes,
All right, so Mr. Boone, I didn't have you down for coming in person today, but your attorney thought you were coming in person today. Are you okay being here via Zoom?
yes,
Okay, Mr. Malaro, do you need a breakout room with Mr. Boone?
I do, Your Honor.
All right, so I am going to open a breakout room. Let me see here. And Mr. Boone, I'm gonna put you and Mr. Malaro into that breakout room. All right, go ahead and join.
The dentist?
Dennis, I think so.
Okay, he's one that used to have the old, I
Although that was Pierre Tetters. So maybe it's his son.
don't know, because didn't he have the annex building?
Yes.
One time?
Along with Endicott, remember? Endicott and
Yeah.
Tetters. Yep,
Okay.
yep. But I think it was Pierre Tetters. I don't think it
Sure.
was, I'll have to look.
Did you see the signs like with the Jackson area? now?
Yeah, I think that's what he's like. I think, yeah.
All right, Ms. Spade?
Yes.
Oh, look, we have matching calendar mouse pads.
What's that?
We have matching calendar
Yes,
mouse
we
pads.
do.
I
Don't you
know.
just love it.
I just love
I
it.
do too. You know what? I love Becky's calendar. Because
The
that
hours.
was a great idea. That was a great idea.
My brother works there at the gas company.
Does he?
He's the accountant.
Okay.
I love these calendars.
So that was Mr. Tedder's. We warm today.
Yeah.
36 degrees. I'm
Yeah.
like super excited. My kids are all pulling for wind chill days because it's supposed to be -23
Oh, my
like
word.
next week,
Oh,
Tuesday and Monday. Wind chill factor and actual -2 next Wednesday. So. Miss Beta, I think this is what you gave. Us.
oh,
This.
okay. What I have, that's probably okay. Mine doesn't look like that. That's.
Maybe
clearer,
Sarah
actually.
just found it somewhere.
Yeah, that could be. That could be. I can give you a copy. Okay. I'm sure that's really clean. That's a nice clean copy.
All right, Mr. Malaro, I will close the breakout room.
Judge, could I talk to Mr. Hartung briefly in a breakout?
Sure. So, Mr. Hartung, now I'm going to, well, Mr. Hartung wants to, but Mr. Hartung.
Well, actually, there's no one in the courtroom, right?
But we're live on YouTube because, you know.
Yeah, okay, I better talk to Doug in a breakout.
Okay, so Mr. Hartung, I'm going to place you and Mr. Malaro into
What are you in
a
your bathroom,
breakout.
Mr. Hartung? Is that your shower curtain?
It is. Don't speak ill of Natalie Kasaka's drapes. She made these 1,000 years ago, and I never moved them.
I was gonna
you're
say
at
they're
your
lovely.
office.
They're lovely.
No, he's at his office.
Yeah, I'm at the
We
office.
don't ever speak ill of Natalie Kasaka. She
Absolutely
was
not.
a goddess. Okay, go ahead and join your breakout room. Mr. Boone, that looks good.
How you doing today?
I'm good. I like your hair.
Thank you. Thank you.
You're welcome. Somebody on iPhone, so let's see who they are. All right, I've just had somebody call in on an iPhone. Could I ask your name, please? Unmute your device and let me know who you are.
Yep, this is Sarah Sinclair.
Sarah from where?
Sarah Sinclair.
Oh, okay. Thank you, Miss Sinclair. Is it Sara or is
H.
there an H on
There
H?
is an H. Yes, thank you.
Okay. Okay, I've changed your screen name. There might be a little bit of a time delay before Sinclair, so I'll bring you in when I call the case in a few minutes, all right?
Thank you.
Thank you. All right, Mr. Malaro and Mr. Hartong. All right, so we are back on the record. Do you need a breakout with Mr. Do you need another breakout room with Mr. Boone, or are we good?
I do not, Your Honor. We will be fine.
Okay, let me grab his file. This is in the matter of the people of the state of Michigan versus Jason Allen Boone, file number 24-21982FH. Says the date and time I have scheduled for a plea. I do have a plea agreement form in the file. I don't know if I said it, but I think I did, but Mr. Hartung represents the people and Mr. Malaro on behalf of Mr. Boone. So the plea agreement form is he would plead guilty to count 1, delivering manufacture without a narcotic supplement, count 2 and 3, as well as the habitual offender supplement would be dismissed at the time of the plea, so it would remain a 20-year max, and that there is a Killebrew agreement that he would be sentenced to 27 months to 240 months. It's a Cobb's agreement. I'm sorry. Looks like, is it Cobb's, right, Mr. Hartung?
Your Honor, we had a bench conference and you agreed to do that for Mr. Boone. And also one more thing, the plea agreement form does not reflect that counts 4, 5, and 6 will also be dismissed.
Okay. The only reason I said that is paragraph A, they acknowledge the Cobb's evaluation held on December 9, and the court committed to 27 to 240. Does that mean you had a Killebrew and I just had no objection to it? Is that
I think
what you mean?
that's probably the better way to put it.
Okay. All right. So, Mr. Malaro, is that your client's intention today?
It is, Your Honor.
All right. Mr. Boone, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. You can put your hand down. So you are Jason Allen Boone, correct?
Yes, ma'am.
Now, Mr. Boone, you have heard the statement I made as well as the agreement and additions by Mr. Hartung and Mr. Malaro. So is it your intention to, okay, is it your intention to plead guilty to count 1, delivering manufacture of cocaine with no drug sup, and count 2, 3, 4, 5, and 6 would be dismissed, as well as the habitual offender. So it would remain a maximum penalty of up to 20 years in prison. So is that your intention to plead guilty to that count 1?
Yes, ma'am.
And you understand the agreement between the prosecutor and the defense attorney is that I will sentence you to 27 months to 20 years to Michigan Department of Corrections. So you understand that?
Yes, ma'am.
All right. Are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, ma'am.
Okay. Neither the prosecutor, the defendant, nor anyone else on your behalf has discussed any other sentence with the court. Is that correct, Mr. Hartung?
Yes, Your Honor.
And Mr. Malaro?
Yes, that is correct, Your Honor.
All right. So, Mr. Boone, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Boone?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Boone?
No, ma'am.
All right. So, Mr. Boone, how do you wish to plead to the charge that on or about August 13 of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of controlled substance, delivering, manufacture of cocaine less than 50 grams? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, ma'am.
All right. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty?
No, Your Honor.
Has your attorney promised you any particular sentence other than the agreement we entered, or estimated what any other part of your sentence would be in terms of fines and costs or anything like that?
No, ma'am.
All right. Is it your own choice to plead guilty, Mr. Boone?
Yes, ma'am.
All right. So, Mr. Boone, on August 13 of 2024, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
And Mr. Boone, did you have less than 50 grams of cocaine in your possession?
Yes, ma'am.
All right. And did you possess that with the intent to sell it or give it to somebody?
Yes, ma'am.
All right, Mr. Hartung, and you had no legal right to possess it, correct, Mr. Boone?
No, ma'am.
All right, Mr. Hartung, are you satisfied?
Yes, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Hartung?
It has, Your Honor.
Mr. Malaro?
Yes, court has.
All right. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has agreed to honor the Killebrew agreement that was placed in this matter, and will, at the time of sentencing, agree to sentence him to 27 months to 240 months. I'm going to refer this matter to the probation department for a pre-sentence investigation. Miss Adams, what are we still, what's the date we're using for sentencing?
Judge, we are using February 28th at 8:15.
All right. So, Mr. Malaro, are you available on February 28th at 8:15?
I am, Your Honor.
All right. So, Mr. Boone, you do have the right to appear in person, or you can appear via Zoom. How would you like to?
Zoom.
You want to do Zoom? Okay.
Well, I'll come in person. I'll
You
come
want
in
to come
person.
in person?
Yeah.
Okay. All right. So we'll make sure that's in person. Now, Mr. Boone, you're not on parole right now, are you?
Yeah, I'm on parole. I already know the rules.
So who you want? Are you out of Wayne County or here?
Wayne County.
Okay. So credit wise, he's not eligible for any credit. Okay. You understood that, Mr. Boone?
I already know.
Okay. I just want to make sure you know that. All right.
Yeah, I
So,
already
okay. So, Mr. Boone, someone from our probation department will come over and meet with you. They'll do a pre-sentence report, be truthful about your background, the events that occurred. We'll get a copy to Mr. Malaro. He'll review that with you in advance. And then we will see you back here on February 28th at 8:15 in the morning. Anything else, Mr. Hartung or Mr. Malaro?
Your Honor, if a date opens up sooner, we'll be happy to make the adjustment in the date for Mr. Boone to get this thing rolling sooner as opposed to later.
Okay, very good. All right, so thank you, Mr. Boone. You have a good day, okay?
Now you too.
Thank you.
I'm Mr. Malaro.
All right, I'll talk to you, Jason.
All right.
Thanks, Sam.
Yep, thank you, Mr. Hartung.
All right. Deputy you're all set. You can go. All right.
Okay.
So, Mr. Malaro, you represent Mr. Sinclair, right?
I do, Your Honor.
All right. I do not have fingerprints on him, so I'm gonna bring him in
Oh,
and then order him. He just never went and did it. So, Miss Berger, nice to see you back. All right. Okay. So, so what is this one? The gentleman's name?
Turn back. But then better.
All right, so. All right, so Mr. Mack, Mr. Noe should be here shortly. And then I'll probably take the two of you back to the jury room and sit down and talk to you, okay?
Thank you so much.
All right, thank you. All right, so let's bring in. There. Counsel, what's your name, please?
Taylor Ward.
All right, okay. What case?
Amy Cheney versus Bella Blue.
I know that's my case, but I don't have them on my docket. So, Miss Adams, it's Bella Blue Pools, right? Miss Adams, I have a gentleman counsel here on Bella Blue Pools, but I don't show it on my docket. If it was a bench, did you guys have it set for bench trial?
We have a jury trial set February.
Which one is it on there?
Mine's different than yours.
Oh. It's so different that I don't have it. Okay, so we'll figure that out in a minute. All right, so in the matter of the people of the state of Michigan versus Matthew Richard Sinclair, file number, I don't even have a file. File number 24-21920FH and 24-21991FH. I have Salvatore Malaro appearing on behalf of Mr. Sinclair. And I have Isaac Sneed here on behalf of the prosecutor's office. I don't know if he's here on this case or not. But I have a note in my file that I am still missing fingerprints on file number 24-21991FH. And that is a City of Adrian case. I mean, he got arrested that night. How would they not fingerprint him? Miss Adams sent an email out to the public defenders. Miss Adams, is it possible that we can make a call to APD so or I can email?
Judge, Martina reached out to APD for me yesterday and we haven't heard anything back.
All right, so Mr. Sinclair, we're missing fingerprints on one of your files.
Okay.
And so sometimes what happens is they fingerprint and process it for one file, but they don't fingerprint and process for the other file. And so if you can just give us a few minutes, we're gonna call APD and see if we can track that down, okay?
Okay, yeah, I know I was fingerprinted at the jail. They did that in a DNA swab. If they need me to, I can get up there today and get another copy for them or whatever.
Okay, so we'll call the jail too. So just bear with us for a minute, Mr. Sinclair, and I'm gonna put you and Sarah Sinclair into the waiting room. I don't know what you can see or not, Mr. Sneed. I'm not familiar with your system, so if that's what you turned on your video for, but all right, so now we're back and I have Mr. Rogers. So this is in the matter of the people of the state of Michigan versus Scott Allen Rogers, file number 21-20250FH, 21-20251FH, 22-21010FH, 24-21764FH, and last but not least, 24-21815FH. Now, multiple of those files are being dismissed. So we are only today sentencing on file number 24-21764 and 24-21815FH. And the other files per the plea were to be dismissed at the time of sentencing. Is that correct? Are you here on this file, Mr. Sneed?
Yes, I am. Good morning, Your Honor.
Good morning. All right, so Mr. Rogers, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Well,
Okay.
Your Honor, am I muted? Oh, there we go.
I can hear you.
Judge, there's been a corrected and updated report. I do need to review
Got
that.
it? Yep. I got one that's in highlighted in big letters at the top that says corrected. Do you need a minute to review that with him?
I do, yes.
Okay, so Mr. Rogers, I am going to open up a breakout room and I am going to assign you and Mr. Malaro to review that pre-sentence report. So go ahead and join.
Judge.
Ms. Teskey, I know there's a bot too.
Okay, that's, yeah.
I call booking, they tell me if someone's been booking.
They should be able to look it up.
Hi, this is Judge Anzalone. I have a question for you.
Yeah.
So I have a sentencing today on a file on Matthew Sinclair. And it's file number 24-21991 FH. But let me see what the district court file number was, because we show he wasn't fingerprinted, but he said he was fingerprinted at the jail, even though it's an APD case. So let me see if I can find the misdemeanor file number. So hold on. The misdemeanor file number would have been 20.
Technical warrant, because it'd be easier for them with the case number.
Oh, do you want the?
So you get a case number.
I'm looking for the warrant. Doug said it would be easier. They don't send stuff up to me like. They send me.
Was it like an R&O operating while intoxicated?
Yeah, I have. Yeah, it's an R&O OWI open container file to stop. It looks like it's file number 24-2095.
Let's see. They did not log that he got fingerprinted, so he may not have.
Okay, awesome. Thank you so much.
Yeah, you're welcome. Good day.
You too. Bye-bye.
Bye.
Becky said she received an email that that case was settled. I think she emailed you too, but she said that case was settled.
Miss Adams, could you yeah, here we go. All right, so, I'm gonna put the courtroom in the waiting room for a minute. So. You're welcome. Thanks.
You're welcome.
I figured Mr. Noe wasn't too big of a threat to me. He's always nice, so. All right, Ms. Teskey, just be a few minutes.
Okay, that's fine. Hey, Isaac,
Yes.
need your email.
Do
Have
you guys want a
emailed
breakout
me?
room? Do you want a breakout room?
Just, he's got, I
I'll
just
text
want
it
to
to
email
you.
him. Okay. Thank you.
Thank you. All right, Mr. Malaro, can I skip over to Mr. Sinclair? Because I'm going to have to adjourn it for fingerprints.
Judge, there's one thing and since if Mrs. Sinclair's here, I think Mr. Sinclair wants to address the no contact provision, which,
Well,
because I don't,
hold on,
well, I'll
let me
wait
call
for
the
you to
case.
bring him in.
Let me call the case. Hold on. All right, Mr. Sinclair, all right, this is in the matter of the people of the state of Michigan versus Matthew Richard Sinclair. Mr. Sneed, if you can maybe look the file up real quick. This is file number 24-21920 FH, 24-21991 FH. Mr. Sinclair, you were fingerprinted on one file and not the other file, so I apologize for that inconvenience. We are going to need to get you fingerprinted before I can sentence you. The sentencing today was on a domestic violence first offense and an attempted RNO and OWI. Miss Adams, do I have a date next week that I could sentence Mr. Sinclair?
Yes, we could do Friday, January 24th at 8:15.
Mr. Malaro, are you available January 24 at 8:15?
Yes, Judge.
Mr. Sinclair, are you available that day?
Yeah, that's fine with me.
All right, so Mr. Malaro, I will adjourn the sentencing to January 24th at 8:15. My staff will send out a notice of hearing. Mr. Sinclair,
Okay, somebody's talking.
are you talking to me?
Somebody was talking in the background. It was Mrs. Sinclair.
So Mr. Sinclair, you're going to
Is there case up?
you're gonna have to schedule with the city of Adrian to get a fingerprint done on that file. We will also mail the fingerprint order to you and send it to the Adrian Police Department. And like I said, you're gonna need to call them today and set up a time to get your fingerprints done, okay?
Okay.
Judge,
I
did
know
Miss
the person-
Sinclair? Did she
Hold on,
drop
I'm not
off?
there yet. Hold on, I'm not there yet. She is gone. So Mr.
Oh.
Sinclair, I have some information that the person who does fingerprints is not in. It might be on leave. And so they may send you to the sheriff's department. I don't know, just call them today and work that out, okay?
Alrighty.
All right, and then, Mr. Malawi, yes, as soon as I adjourned it, Ms. Sinclair hung up.
All right. Sorry, Judge.
So we will see you back right away. Like I said, we're not adjourning it. We're just adjourning it long enough for you to get your fingerprints. So we will see you back on January 24th at 8:15. Thank you, Mr.
Alrighty.
Sinclair.
Yep.
Thank you.
I'll call you,
Anna.
Nancy.
Bye.
I'll call you. Thank you, Judge.
Thank you. All right, so Mr. Rogers, I also forgot, you do have some probation violation sentencings on those other files. So I did misstate that. So you have a probation violation sentencing on 21-20250 FH, 21-20251 FH, and 22-21010 FH. And you received those probation violation reports, Mr. Malaro, correct?
Yes.
Okay, so now, Mr. Rogers, have you had an opportunity to read and review the updated or corrected pre-sentence report as well as the probation violation reports with Mr. Malaro?
Yes, ma'am.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes.
All right, does Mr. Malaro, does either the pre-sentence report or the probation violation report disclose any prior convictions in which there exists any known constitutional defect?
Judge, I would state that after reviewing the sentencing memorandum for Mr. Sneed and the corrected pre-sentence report, I cannot argue against it. I think it's valid. And so I would withdraw my sentencing memo, and I do not find any other corrections necessary in the corrected PSI.
Okay. All right, the probation Well, does the pre-sentence report disclose, did I ask about, I was like looking at two reports. So I think I asked, did I ask about corrections or relevancy or anything like that, Mr. Malone? I think I
You
did.
did, Judge, but I threw you off with
Yeah.
my statement. I'm sorry.
And were there any prior convictions in which there exists any known constitutional defect?
Not to my knowledge.
All right, so the guidelines were calculated, and obviously the court does acknowledge that there was a, I believe it was it a Killebrew or a Cobb's, Mr. Steen?
It was a Killebrew, Your Honor.
All right, so there was a Killebrew agreement between the prosecutor's office and Mr. Rogers that he would serve a minimum of 48 months on both dockets. And is that correct, Mr. Malaro?
That is correct, Judge.
And of course, the court will honor the agreement struck by the prosecutor and the public defender's office or the attorney's office. So on file number 24-21764FH for count 1, controlled substance, possession of methamphetamine, the guidelines were calculated to be 10 to 34 months. Do you agree with that calculation of guidelines, Mr. Malaro?
Yes, I agree with that.
And then on that same file for count 2, possession of cocaine less than 25 grams, they calculated the minimum sentencing guidelines to be 2 to 25 months. There was one habitual, so that was an 8-year felony. Do you agree with that calculation of guidelines?
I agree with that one, Judge.
And then on file number 24-21815FH, the guidelines for count 1, larceny less or 1,000 or more, but less than 20,000. The guidelines were calculated to be 19 to 57 months. Do you agree with that calculation of guidelines?
Yes.
And then on count 2 on that file, police officer assaulting, resisting, obstructing, guidelines for 7 to 34 months. Do you agree with that calculation of guidelines?
I agree with that one.
All right. All right, and then it correctly states that on these files, there was a habitual criminal third felony plea is on those charges, correct, Mr. Malaro?
That is correct.
Okay, so before the court passes sentence, Mr. Sneed, anything you want to say on behalf of the people?
No, thank you, Your Honor.
Mr. Malaro, anything on behalf of Mr. Rogers?
I would, Judge, we have a sentencing agreement, but I think if Mr. Rogers is not under the influence of substances and also, he's generally a pretty pleasant person to be around, he's got to make better decisions. I hope he takes his time to do that. I guess the only other issue, Judge, is the report reflects restitution, but it's my understanding that he did not get off the premises of Tractor Supply, so I don't know that there's a need for restitution, but if there is, we'd ask that there be a hearing on it.
Okay. All right, Mr. Rogers, anything you want to say on your own behalf?
No, ma'am.
All right, Miss Teskey, is there anything you need to add?
There is, Your Honor. This has been adjourned out from December 20th, so I would like to update the jail credit.
Yes, ma'am.
On the VOP, he has a total credit of 243 days.
Okay.
And on the new sentence, he has a total credit of 277 days on docket 21764 and 272 days on docket 21815.
Okay. All right. Yep, and that's because of original arrest dates were different. All right. Any objection to that, Mr. Steen?
No, thank you, Your Honor.
Mr. Malaro?
Oh, Judge, thank you, Ms. Teskey.
All right. All right, Mr. Rogers, anything else?
No, ma'am.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. So with regard to the 48 months on the sentencing agreement, 48 months, that would be applied on file number 24-21764FH, Mr. Malaro, to the count 1 controlled substance possession of methamphetamine, correct?
Correct, Judge.
No?
I,
Yes, that's correct.
Mr. Sneen? Well, the plea agreement that I have is that on both of these counts, he would receive 48 months. Right, Mr. Sneen?
yeah, just to clarify, I think due to the scoring issue, the minimum in file 2421815 is 19 to 57 months. Therefore, in that file, the court can sentence 48 to 120 months. In the other file the court just mentioned, 764FH, I believe the guidelines remained the same at 10 to 34. So we would just ask that it run concurrent from file 2421815, and in 2421764, the court can sentence, we'd ask from 34 to 120 months.
That's what I was trying to get to, because thank you, Mr. Sneen, because I know the agreement originally was a minimum of 48 months on both those counts, but the guidelines are 10 to 34, Mr. Malaro, on file number 24-21764FH. So that controlled substance possession of meth is a 20-year max. So Mr. Sneed, you're saying in accordance with the sentencing guidelines that I can sentence him to the 34 months on that file.
I think that's our request, and thank you for allowing me to expand on that.
Okay, thank you. And I'm assuming, Mr. Rogers and Mr. Malaro, there would be no objection to sentencing on that file only less than 48 months.
Correct, Judge. Yes, sorry.
Okay, all right. So in determining the appropriate sentence in this case, the court has considered this seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon this record today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. Mr. Rogers, I wholly concur with Mr. Malaro. When you're under the influence of controlled substances, you get into trouble, you know, and you're a completely different person when you're going through your sobriety. I know you were in recovery court for a little while. You know, I just really hope that you take advantage of the time to further your sobriety, because, you know, when you're sober, this isn't the kind of person you are, and we know that. All right. Okay, so on file number 24-21764FH, on count 1, it's a sentence of the court that you will serve 34 months to 20 years with the Michigan Department of Corrections with credit for 277 days. There's a crime victim assessment fee in the amount of $130 and state costs in the amount of $68. On count 2, it's a sentence of the court that you will serve 24 months to 8 years with credit for 277 days with the Michigan Department of Corrections, and there is a $68 state cost. On file number 24-21815FH, on count 1, it's a sentence of the court that you will serve 48 months to 10 years with the Michigan Department of Corrections, and I will give you credit for 272 days on that file. There is restitution in the amount of $2,399.99 to Tractor Supply Company. Obviously, Mr. Malaro, he has the right to request a restitution hearing. There is a crime victims assessment fee in the amount of $130 on that count and $68 in state costs on that count. On count 2, it's a sentence of the court that you will serve 24 to 48 months with the Michigan Department of Corrections with credit for 272 days already served. And there is $68 in state costs. Those files will run consecutive to, no, concurrent with each other. Is that correct, Mr. Sneed?
Concurrent, yes.
Yeah, they'll run concurrent to each other, so they won't stack, Mr. Rogers. Now, on your violation of probation files, amending.
Judge, I have an update on jail credit. I'm so sorry. I just realized that on two of his dockets, he
Well, hold
already
on.
had 300.
Yeah.
Okay.
So I guess, Ms. Teskey, on file number 21-20250FH and file number 22-21010FH, there's restitution in the amount of $540.58 still owed, correct?
That is correct.
He has a lot of credit on all these files. Mr. Sneed, do the people take a position on whether I revoke and terminate his probation? Or
No position, defer to the court's discretion, Your Honor.
So Ms. Teskey, at this point, in light of the charges he's going to prison on and the fact that the probation violation is recommended to be concurrent, do you have any objection if I just revoke and terminate probation on those probation files?
I do not, Your Honor.
All right, so Mr. Rogers, on file number 21-20250FH, 21-20251FH, and 22-21010FH. The recommendation in the probation violation file was for a minimal prison term. You have ample credit on those files, and you've been on probation for 2 to 3 years on each of them. I am just going to revoke and terminate your probation on all of those files and give you credit for time served. Ms. Teskey will get that credit to Ms. Adams today. And then obviously, sir, you do have some restitution still owed on that. So when you get out, it's not too bad. You'll obviously need to still pay that restitution, all right?
Okay.
Okay, am I missing anything, Ms. Teskey?
Your Honor, you're not. I can place on the record right now the jail credit if you would like.
Yes, please.
Okay. On docket number 21-20250, he has a total credit of 336 days.
Okay.
On docket number 21-20251, he has a total credit of 336 days. And on docket 22-21010, he has a total credit of 243 days.
Okay, so we'll give you credit for that time served on those files. So Mr. Rogers, we're gonna send over to the jail your notice of right to appellate review on all your files. You're gonna get like 5 sets of these, okay? They're gonna have you initial and date a copy on each file. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. So Mr. Rogers, I wish you the best of luck. Hopefully, you'll get into some good programming that'll help you on your way, okay?
Thank you, ma'am.
Good luck to you, Mr. Rogers. All right,
Thank you,
Mr.
Jim.
Valero and Mr. Sneed, thank you so much. And I think that concludes my sentencing docket this morning. Ms. Teskey, take care of yourself. There's like nasty stuff going around. Nasty stuff.
Thank you.
All right.
Everybody
Thanks,
have a nice
everybody.
weekend. Bye.
You too.
Bye-bye.
Bye. Stay